In any criminal case, your ultimate defense is the right to go to trial in front of a jury or a judge. In a domestic violence case, it's no different. The jury trial is your sacrosanct right under our Constitution to have a panel of 12 people determine your guilt or innocence based on that evidence. A number of years ago, the system altered itself to no longer allow the victim of domestic violence to determine whether or not a case will be prosecuted. It used to be viewed as a private matter. If that person decided they wanted to be with that other person, an abusive person, or the person that hurt them, they would just let them do that. It is no longer the case. It's no longer just a private matter between two people engaged in that relationship. The state will use its subpoena power to make sure that that victim, the person who's listed as the victim anyway in the police reports, appears in court or they go to jail. Once you decide to go to trial, and assuming it's a jury trial, the first step in that process is what we call jury selection. It's the process by which they bring in maybe 30 people from the community as potential jurors, and they are questioned one by one concerning whatever matters the court may determine may affect them and their judgment to sit on a jury. Once the jury is selected and impaneled and sworn in, state and the defense both make what's called an opening statement. The state leads off. It's generally a roadmap to what they expect the evidence to show in a case, or what a particular witness will testify to, or what other physical evidence might be admitted in the case, simply to give the jury an opportunity to understand what's yet to come. Once the opening statements are completed, then it's the state's case to prove. They have to prove the defendant guilty beyond a reasonable doubt, which is the highest burden under our court system, and it's reserved exclusively for criminal cases. They'll call their witnesses to testify, bring whatever evidence they might be submitting, and once they're done asking questions of each witness, the defense or myself, I get to then cross-examine each witness and try to obtain that information or answers to those questions that I deem to be important for the defense of the case. And that process goes on until the state has run out of witnesses and rests. Once they rest, then the defense presents their case if they have one, but the law does not require the defense to present any case at all. And oftentimes we don't. We rely on that burden of proof on the state, because oftentimes they'll go to trial on a case that's just not that strong. And you can rely on cross-examination and, in other words, punching holes in the state's case to stop the state from reaching or satisfying the burden of proof. If the defense does present a case, then they'll go after the state, each witness. The state gets to cross-examine each witness, and then finally my client will have an opportunity to testify if they choose to. Once all the evidence in the case is in and there's no more witnesses to testify, then the court allows the state and the defense to make closing arguments, and those are arguments different from the opening statements. The state goes first. They'll make whatever closing arguments they think are appropriate to spin the evidence and the testimony in favor of their case, and then I'll have an opportunity to then get up and argue the defense side of the case, point out the flaws in the state's case, point out where they failed to meet their burden. The hardest part of the trial for any defense attorney is what's called rebuttal, which is because the state has the burden of proof, they get to go last, so they get to make one more closing argument. And after that, then the judge reads the law to the jury through what are called jury instructions, and the jury deliberates at that point. In a domestic violence case or a domestic battery charge, there are frequently a defense called self-defense, which is you are not required under the law to stand in place and take physical abuse from somebody. You are allowed to protect yourself within certain bounds. And often in domestic violence cases, because there's so much at stake as far as potential custody of children sometimes those incidents don't happen at all. They're simply reported as domestic violence, but they never happened. But those are the two most common defenses in domestic violence cases, domestic battery cases, are the case simply didn't happen at all and simply a fiction, or a self-defense situation where oftentimes people are trying to leave the circumstances but aren't being allowed to and move to defend themselves from that. While I talk about false allegations being fairly common in domestic situations, there they're not common in the larger scheme. No, there's usually a real basis to proceed on a case, or probable cause to proceed on a case on the state's behalf. If you are found guilty or plead guilty to a charge of domestic battery, it has long-term and permanent consequences. In our state, you cannot have your record expunged. You can never own a gun under state or federal law. You are strictly prohibited, and there is no way to undo that down the road if you plead guilty. Most cases do settle without going to trial. Part of the reason they do settle is because going to trial is a gamble. There's an element of risk involved because the outcome is uncertain. And if you don't reach an agreement and you go to trial and you were found guilty, the consequences can be even more serious than they were during the negotiation process. So going to trial is a very big deal, and it always has that element of risk. And that's why you need somebody who's done this, gone to trial many times and handled many cases to help guide you through that process of making that decision.